Instagram. Good morning, YouTube. Good morning, Facebook. Come on in. Come on in. This is your first time tuning in. Welcome. Good morning. Hope everyone is doing great. If this is your first time tuning in, welcome. My name is Aisha Chidole. I'm an immigration lawyer. I represent clients all over the United States with their immigration matters. We handle family-based cases, family-based removal cases, some detention cases, humanitarian-based cases, appeals, and all of that good stuff. The only thing we don't handle is employment or business immigration. All right, so I have a really good topic for you guys, and I'm just gonna get right into it. But before I get right into it, if you want to schedule a consultation, call our office 407-995-6567, or you can send us a WhatsApp to 404-333-8751, or you can call our other number, which is 678-325-1037. Okay. Okay. All right. So today we're talking about something that confuses so many people: the differences between filing under VAWA with an I-360 and filing an I-751 waiver based on abuse. So what you need to understand is that they're not the same thing. And let me apologize in advance. I'm working from home today. My kids are home. I guess they had 2 days President's Day. So in case you're hearing like some background noise and the lawnmower going off, pardon all of that. Anyway, so these two case types, they don't apply to the same people, and choosing the wrong path can seriously delay your case, or sometimes you might already be a green card holder. Like, I can't tell you how many times I have people who are already green card holders filing an I-360 and then get denied, and it's like you just wasted 3 years and just restarted yourself when you could have filed the correct one. So if you're in a marriage that is abusive, or you're afraid because your spouse is threatening your immigration status, stay with me here, or share it with your friends or family that might be in this situation. So first, let's start with what is VAWA and who qualifies. So, again, most of you know VAWA. If you don't know, VAWA is Violence Against Women's Act, and it allows certain immigrants to self-petition without the abusive U.S. citizen or permanent resident spouse. And typically with that, you're going to be filing a Form I-360. And so you may qualify if you meet one of the following. You're married to a U.S. citizen or permanent resident. You suffered battery or extreme cruelty. The marriage was entered in good faith. You live with the abuser, and you have good moral character. Okay? Something that is important to note is that VAWA is for people who do not already have permanent residence through that spouse. Let me repeat it. VAWA is for people who do not already have permanent residence through that spouse. Okay? So in this case, you're basically asking USCIS to approve you on your own as a self-petitioner without your spouse. Now, what is an I-751 abuse waiver? I mean, I can't believe that these lawnmowers are coming right now while I'm mowing the lawn. I don't know if you guys can hear me clearly, but if the noise is too much, I apologize. Okay, so what is an I-751 abuse waiver? So this is very different from an I-360. This applies only to someone who already received a 2-year conditional green card through marriage. Okay? So an I-751 abuse waiver is if you've already received a 2-year conditional green card through marriage. Normally, you file I-751 jointly with your spouse to remove the conditions. But if there is abuse, you can file it alone, with a waiver. We call it the I-751 waiver based on battery or extreme cruelty. So if you're filing it based on that, you don't need your spouse in that situation. You don't need your spouse to sign off on this. So in this case, you're not asking for a new green card, okay? You're asking USCIS to remove the conditions on the one you already have. So note the difference. In the 360, you're asking for a green card because you never had a green card. In a 751, you're asking for them to remove the conditions on the 2-year green card you already have. okay? So let's kind of do like a side-by-side comparison, right? So VAWA I-360, for people who do not have a green card yet, you self-petition and you file an adjustment of status, meaning you file an I-485. The process is generally longer, but it eventually leads to permanent residence, okay? With the 751 abuse waiver, this is for people who already have a conditional green card, no spouse signature needed. You remove the 2-year condition, and during that time, you keep your resident status while it's pending. From a timeline, because I already see some people asking the question, most VAWA cases are going to take somewhere between 3 years to 3.5 years for VAWA to be approved and then adjustment of status. Removal of conditions on a normal basis can take 24 months. However, if you are eligible for naturalization, meaning citizenship application, you can kind of accelerate that, which you can't really do in a VAWA case unless you are eligible for an expedite. Okay, so so let's just clarify. What is extreme cruelty, right? In the case of either of these two situations where oftentimes people think that it only has to be physical. Extreme cruelty is going to include things like emotional abuse, financial control, immigration threats, isolation, humiliation, and manipulation. So if you fall under any of this, you might be eligible for one or the other, depending on whether you have a green card or not, right? So, let's see. One question that people generally ask, about both of them is, do you typically need a police report? So a police report, whether that's for conditional green card or for VAWA, it's not required, but if you have one, it is helpful. Every helpful information is credible information and can support your case. Obviously there was a time where people were less afraid, right, to go file a police report. Now, for a lot of people, there's true fear that, the police is working with ICE and then we report them to ICE. So like I said, I think I said this a couple of weeks ago, if you find yourself in that situation, one of the things that you want to do is you want to try and, if you can't go to the police, go to the doctor, go seek, medical help, go get a psychological evaluation if more of your abuse is emotional and psychological. If it's something that there's any kind of injury or you have any physical injury or physical assault, go to the doctor, go get checked up. Like if you don't have the courage, to file a police report. If you do, or the police are called or for whatever reason, you can do that. If you have a spouse who's threatening you and harassing you, get a restraining order. This is usually civil, in most states. So you want to do that. Okay. Let's see what else I want to talk about. All right. So that's really what I wanted to talk about. I'm going to jump right in to questions. Okay. And see. So this person is asking one more thing. If I want to withdraw from my VAWA and get married again and file a new case, how do things work? Either this is your first time tuning in, I'm not sure, but honestly, you would know that I don't support that. You can do it, it's your personal choice, but people sometimes feel that, I've met someone new, I don't want to wait too long for my VAWA case, let me just marry. But listen, a marriage-based green card, if you're eligible for VAWA, doesn't guarantee that your green card is going to be approved, because it doesn't guarantee that you're going to have a better spouse this time. It doesn't guarantee that your spouse is not going to be, show up and sabotage your interview. It doesn't guarantee that if you and your spouse get into any kind of infraction, they're not going to use your immigration status to threaten you. So it's never a good idea, if you are eligible for a self-petition through VAWA, that you don't go that route, unless you're telling me that you absolutely have a very weak case. That's a different story. Now, so that would be my answer. If that is the case where your case is extremely weak, you don't have anything, sure, you can withdraw if you want to withdraw, but the minute you marry someone, when you have a VAWA pending, you're no longer eligible for the VAWA application anyway. Okay. Someone says, I filed for VAWA since 3 years, no decision yet. VAWA cases are taking a long time. 3 to 3.5 years. So that's kind of what we're seeing right now. Okay. But hopefully, if you have a VAWA case and you're hopefully eligible for adjustment of status by now, even if you're married to an LPR, if it was 3 years ago you filed, by now you should be eligible. And if you're eligible, hopefully you at least have a work permit, which allows you to work, which is what essentially the green card will allow you to do, work and travel. So you can at least hold on to that while you're waiting for your case. Okay. All right. So let me take some questions on Instagram. There's so many, so I'm just going to get to whatever I see. Okay. All right, guys, just hold on. I'm trying to see when that makes sense. Why is it so long to get a biometric appointment for VAWA? I don't know. You'll have to ask USCIS that. I don't know the answer to that. How long does it take for a decision for VAWA after submitting? I just talked about that. 3 to 3.5 years minimum, unless you qualify for an expedite. Is I-751 on pause? I-751 is not on pause. Guys, please stop the misinformation. I feel like I talk about this every single live. Please, guys, stop this. You got to stop this misinformation. Okay? The 75 country pause are for people outside of the United States applying for consular processing outside of the United States, meaning they are outside of America. Okay? There are 39 countries, which I'm not going to list right now, that have what we call an adjudicative hold in the United States. If you are part of those 39 countries, there is an adjudicative hold that as of right now is 90 days. They've told us that for 90 days from January 1st, there is an adjudicative hold so that they can decide the level of scrutiny they want to review these applications. Now, 90 days is April 1st. We don't know what level of scrutiny they're going to start using to start reprocessing, but those 39 countries you can still submit your application. They're still being called for biometrics, 50-50 for interviews. Some of them are being scheduled. And, I even told you guys about one of our clients that went to the interview. Some are not, some they're rescheduling their interviews, but they are still you should still be going to your biometrics. You should still be getting your receipt notices. You should still be getting your I-751 extension receipts, because we are getting it in our firm. So if you're not getting it, I'm not sure why you're not getting it, but we are getting it in our firm. Maybe I need to start posting some of those. I don't know if some of those receipts have a country so you guys can see, but please, guys, stop spreading false information. Can you use a pending VAWA petition to support an I-751? No. All right, let's see. My VAWA started September 2022. My case was transferred to a new field office 1 year to date. How long before they make a decision on my green card? Honestly, I can't answer the question. I don't know. I filed for VAWA. I received my social security number, work permit, which is expired, advanced parole, but I haven't received anything yet since 2023. Obviously I can't give you legal advice on the call because you're not my client. But that said, if your work permit has expired, you should be filing for renewal on your work permit. You filed in 2023, you're still in a normal processing time, depending on when in 2023, unless you qualify for expedite. Ronka says, can we also have beauty videos, the blush, the hair, the lip color? Thank you very much. I really appreciate that. I actually use a face tint. I don't use foundation because it's just too heavy doing makeup every day. And it's just a lip gloss that I use called Eden. And it is called Bissap Place lip gloss. And then, I use like some kind of liquid blush that my kids told me about, and just mascara. That's it. Okay. I have a 5-year work permit for my VAWA case. What am I going to get next with my case ending this year? Hopefully a decision, or if they need additional evidence, hopefully you're able to answer the request for additional evidence. I've gotten 3 prima facies through VAWA from 2022. and now my current FASHA expires from December. You should fully be expecting a new one. Usually you don't have to reach out to them. They would normally send this automatically to you. So they automatically send it, but they are notorious for sending them late. So even if you haven't received it, you will still get it, okay? Okay. Filed I-485 based on approved VAWA. My daughter's own got approved, but no card was sent. Now everything is on hold pending a change in policy. I don't know if you're asking a question. Can you confirm that your daughter's, so if your daughter's case was approved, when was it approved? If her case was approved, you should request, usually you can request stating that you didn't receive the card. I don't know if you received the actual green paper letter. I don't know if your daughter is outside the US or in the US, so it all depends. So given strategically, it's hard for me to say actually, is your daughter outside the US or inside? Let me know what she is. Can I file for advance parole while my VAWA is still pending? You can file for advance parole, which is a travel permit for those who don't know, if you have an adjustment of status, which is an I-485 pending. If you don't have an I-485 pending, you can file an advance parole, okay? I submitted my VAWA in September 19th of 2025, but yet to get a receipt notice. Is that normal? Yes, that is normal. I 100% bet that you probably submitted to Nebraska. Lincoln, Nebraska is notorious right now for the most amount of delays in receipts. Late September, they changed their address for where people can submit their VAWA applications. So they're sending it to different locations depending on where you live. So anyone still stuck in the Lincoln, Nebraska, those are the people that still getting that sprinkle. It's very, very frustrating. It is frustrating to me as well, frustrating to my own clients as well. But this is Lincoln, Nebraska, and why they've expanded locations so that people can get it from other places, okay? Annie says, approved November 16, 2024, Nigerian national. I find that rather suspicious that you approved in 2024 and in 2026 and you didn't get your green card. That doesn't make any sense. Definitely need a consultation to understand what's going on. What approval exactly did you get, VAWA or the actual green card? Because that doesn't make sense that you got approved in November and a year later you got a green card approval and you still didn't get your actual green card. That's odd. And you shouldn't fall within the pause and stuff. Okay, let's see what else. What are we going to do for the partial countries who have pending VAWA cases? There's nothing to do. Your case is still pending. The cases are on hold. They're still accepting those cases. They're just creating new standards, meaning they're going to just have extra scrutiny. So if you know that you're from one of those 39 countries, you really need to dot your I and cross your T. You really need to have a solid case. You really need to have sound legal advice and strategic advice. You really need to think about all your past immigration history and things that you submitted in your B1, B2, because I know for those clients, when people ask, about stats and whatever it is, like people that I see in my own practice that don't get their cases approved are people that are not completely honest, and that is the truth, or we find out things after the fact, like something they lied about in their tourist visa or lied about being married to get a tourist visa, and they really weren't married. And then they're asking them to provide a divorce decree, and there's really no divorce decree to provide, or they doubled down and submitted an application, and then now they want to come to us to help and just kind of like make it all go away. The thing is, whatever you submit to immigration, it doesn't go away. Your history continues. And that is why it is very important, especially those of you that want to DIY it, and then when you get in trouble, you want to then hire an attorney. You should be hiring an attorney in the first place, and you should be speaking to an attorney in the first place to know whether or not you should even be submitting any application. Because what happens when you do that, and you've put your stuff into the atmosphere, which is what I essentially call it to USCIS, we can pull it back. If you've submitted an invalid divorce, you can pull it back and go fix the divorce, or get that sound advice. So you really need to not be penny wise, pound foolish, where you're like, I'm not going to spend money on that. I'm just going to do it myself. I can read this stuff. No, you can't. It's not just about reading it. We see the trends. We see what it is that USCIS wants. Reddit is not going to tell you what it is, what the deal is, or those Facebook groups where people are like, oh yeah, I did this myself or whatever it is, because every single case is different. People will never, even your close friends will never tell you what is going on in their own personal lives and what is happening with them. So, take it from the experts who actually see different scenarios on a day-to-day basis and should be able to advise you. So, if you are from those countries, you should be fine. If you already filed your pending VAWA case, your case will still process. We are just waiting for that hold, which hopefully will end, or hopefully the standards are not too crazy. But the thing is, again, file a solid application so that you don't even find yourself in that situation. When people get upset when we say, I can't take your case because you're not eligible for something, and they get upset that you don't want to take their money, to get them denied. The reason is because, to me, my credibility and integrity matters so much to me. And it matters so much to me because when people come to me and hire me for something as important as their green card or citizenship, which not only changes the trajectory of their life, it changes the trajectory of their family's generations to come, right? It is important for me that I have respect and my firm has respect with USCIS. And they know that if we bring a case to USCIS, it's not a frivolous case, and it's because we believe and we can fight down to the end for that client. So if I say, your case is not approvable, this is not about, whether or not where it's semantics, whether 50-50, well, USCIS may say your evidence is weak, but we can argue it down. For most case types, there are certain elements that make you eligible for papers, right? For a green card or naturalization. And those elements have to exist to make it even viable or possible for you to be eligible. And so sometimes when we say that, it's not because we don't want to accept you. We want to make sure that you meet the elements, or you go meet the elements before you submit something. Because when you submit frivolous applications, all in the name of, let me just put it in there so I can get a work permit, it discredits you. And it not only discredits you, it discredits people from where you're from, right? So keep that in mind, guys. I didn't even realize what time it was. I got to jump off, guys. But I will be back live tomorrow, unless I have an interview. I might have an interview, but I will confirm. But otherwise, if I didn't get to your question, I'm happy to answer with a consultation, which is always preferred, so you can get a personal one-on-one. Otherwise, come on live tomorrow, and if it's generic, I will answer at 10 o'clock Eastern Standard Time. All right, guys, have a great day. Bye.